There's no mic, but I need to be that one, but it should work from all around. Okay. All right, well, we'll go ahead and get started since we have a very full panel. Good afternoon, everyone. It's such a pleasure to be here at this beautiful and historic campus. Welcome to those of you listening from online as well. I am Sandra Nichols-Cham. I'm an Associate Vice President at the Environmental Law Institute and co-leader of the Climate Judiciary Project at ELI. ELI exists to advance environmental law to accomplish societal imperatives. There's no imperative greater than ending climate emissions. While our work is framed around law and governance, from the start, ELI's founders, at the time of the birth of the modern era of environmental law, recognized the critical role that science plays in all environmental decision-making. And they tasked us with a focus on science and law to advance environmental objectives. As a result, science and the critical interactions of science and law are a thread across ELI's work, including our education programs, and most particularly our judicial education program. Another critical thread and part of ELI's DNA is that of seeking to advance equity and justice through our work. In every democracy around the world, judges play a critical role in protecting rights and enforcing rule of law. For 30 years, ELI has been educating judges on environmental law and related issues. As climate litigation is increasing in the US and worldwide, we have launched the Climate Judiciary Project, working with leading climate scientists to educate judges on the facts of climate science and its economic and social impacts. So to touch on these themes and related topics, we have a really fantastic panel today. I'm so excited to have this great group here. My colleague and collaborator, Dr. Paul Hanley, will tell us a little bit more about the Climate Judiciary Project. But first, let me introduce everybody, starting with Paul. Paul is a visionary who, over the course of his career, has sought out and identified pivotal points in society and environmental decision-making where science is critical, and has developed education programs and strategies to ensure that decisions are made with appropriately reflecting science. He's former president of Climate Central and is the founder of the Climate Judiciary Project. Our next speaker will be Dr. Miles Allen. He is the professor of geosystem science at the School of Geography and the Environment and the Department of Physics at the University of Oxford, as well as the director of Oxford Net Zero. And Miles is distinguished by the fact that 18 years ago, he wrote a seminal paper about the scientific underpinnings that can support arguments about attribution of extreme events in court cases. Next, we'll be hearing from Judge Marcus Livio Gomez. He's an innovator in linking science and the judiciary. He's a federal judge from Brazil, and he is the lead of the Innovative and Unique Environmental Observatory of the Judiciary in Brazil. I got out of order, but then we'll have, well, actually first, right after Paul, we'll be having John Pendergrass, my colleague. He is the vice president of the Environmental Law Institute. He's a leading international environmental jurist with deep expertise in numerous critical environmental topics. And he's used that expertise over the course of his career to educate many actors on environmental legal tools and approaches and their rights and responsibilities. And this includes thousands of judges in almost 30 countries. And last but absolutely not least, Ariel King is an outstanding advocate who leads ELI's work infusing justice, equity, and public participation to advance environmental and climate justice. And we're just so thrilled that Ariel recently joined ELI and is leading us on our environmental justice and climate justice efforts. So without further ado, Paul, do you want to?
Yeah, just a couple of comments. Take my mask off. When I retired from Climate Central, I was looking for something to do, something that could build upon about a decade of work in climate science. And it appeared very clear to me that the groundbreaking work that Miles Allen and others have been doing in attribution of both extreme events and, generally speaking, climate, was going to be very important in cases, court cases, the growing number of which were coming to judges in the United States and throughout the world. And it seemed to me that it was important for the judiciary, who are, after all, very highly educated in the law and highly respected and wise people, but who are not expert in the science of climate, could, if there were a possibility of this, might choose to and benefit from education in climate science prior to hearing cases, so that they would have a better basis for making judgments that they have to do. And did a little bit of checking with the scientific community and found, importantly, that climate scientists were very interested in engaging with the judiciary about climate science, the objective facts about it, and not politically based, but rather where the mainstream science is. And so importantly, they agreed to do this in an informal survey. And what I thought would be important to do then was to test and see if the judiciary was interested actually in this program by running a pilot program, which Sandy and I ran for a year. And what we found is immense interest in this kind of educational program. And we also found that it was important and useful that institutions, leading judicial education institutions, were willing to partner with us to do this. So the Federal Judicial Center and the National Judicial College of the United States. I'll just stop here by saying that this is beginning to be scaled. We're speaking with a large number of US judges, and we're now ambitious to advance to helping the global judiciary. And that'll be part of the discussion that comes here at the COP and with Judge Olivia. And I would just say finally that what you're going to hear from our panelists today really is very important information that helps to connect science, the law, and how this will impact the implementation of these new ambitions that we're hoping coming out of. Glad.
Jay?
Sandy and Paul, welcome to everyone. As Sandy mentioned, the Environmental Law Institute has been around for a little over 50 years, and science and the law have been linked from the very beginning of the Environmental Law Institute, despite the name of the institute. We are a multidisciplinary organization. We are a think and do tank. ELI makes law work for people, places, and the planet. And I think I know we chose those words very deliberately, that we're making law work for people first, and places on the planet as well. But we are trying to promote sustainable development. So moving to this specific topic, climate goals, their goals. How do we reach them? That's where compliance and enforcement of the targets come into play. And compliance is a multi-level, multi-actor process, starting with individuals, companies that are taking action to affect what their emissions are. We think of, we're here at the COP, it's an international body, generally thought of as states action, but you know, it depends on the actions of many others. So first there's voluntary action, but there comes a time when there's a need for enforcement or compliance that is under the legal system. And as I hope we all understand, judges, the judiciary is at the apex of the legal system. They are extraordinarily talented as a group if you look at on a global scale. But their training is in law. It's not in science. Actually, one of the things that we learned more than 30 years ago, we had a judge giving a speech to the Environmental Law Institute and the Environmental Bar in the United States, and he challenged us to educate judges about the environment and about environmental law, because as he said, it's not a topic that judges tend to be familiar with, and there's a need to educate them. So the Environmental Law Institute took that on. But one of the things that, a couple of points that Paul made are kind of the hallmarks of what we feel is important when you're doing knowledge transfer or education, and that is making sure that you know who your audience is and what they need and want. So the first steps that Paul talked about going through of talking with the scientists about what are the issues that they see are important, and talking to the judges about what they see as important and coming from them, what they might be missing. And so we have taken that, Sandy and Paul on the team, take that and say, all right, what can we do? One of the keys is judges are not going to be scientists. They don't need to be scientists, but they do need to understand both the scientific method, the way that science operates, the kind of knowledge that you get from it, and then how a judge in deciding a case can use that, and how they can evaluate the science that's brought to them by the experts. So the education that you do for judges about climate and climate science is grounded in what are the basics, and how do we know that. It's not intended to try and make the judges expert or substitute for the evidence that's going to be brought before them, but rather help them to be able to understand and use that in their process. So we think that providing this kind of knowledge is critical to the judicial process, which is itself critical to achieving the targets that are set as part of the lawmaking process. We'll stop there and let us move on.
Professor Allen, thank you, Dave. Professor Allen.
Thank you very much. So just say straight away, of course, I very strongly support the work the ELI is trying to do. One of the things which I find striking whenever I go to a COP is how many things are completely obvious to one community and completely alien and unknown to another. I was just chatting at the end of the previous panel. I mean, how many people involved in Article 6 negotiations are aware that an exchange between methane and CO2 actually causes global warming, even though it's denominated correctly and all the rules have been applied and there's no problem with that activity? I mean, and yet every climate scientist, well, yeah, of course it does. It's to do with the lifetimes of the two gases involved. So, and that's something which is completely obvious to climate scientists. You know, anybody who works in the area knows that. And yet we have an entire COP process which is supposedly not causing global warming, causing global warming. Doesn't make a lot of sense. So it's very easy. So it's incredibly important for the really well-grounded, recognized sort of 30-year-old science gets through to these other communities. And increasingly in my career, I found myself over the past sort of decade or so, having spent, well, perhaps the first 15 years of my career making things more complicated. I've spent the second 15 years trying to undo the damage. And and really working on this, what are the things that judges actually need to know, which very often the academic community is quite bad at telling them. We produce these, massive IPCC reports with completely opaque summaries for policymakers and carefully negotiated text, which just don't communicate these things. You will not find this information that exchanging CO2 for methane causes global warming anywhere in the sixth assessment report, because no country will allow that to be said. And, I mean, it's staggering, the gaps, and you're just meant to know that because we can't say it. So, more power to you. You've got a lot of work to do. But on that sort of positive note, if it is, I wanted to illustrate the particular topic of this session with an anecdote. The only time in my life, touch wood, fantastic, isn't it? But I'd actually been hauled up in front of a judge was in 2018. I was hauled up in front of the District Court of California to give a climate change tutorial, as the court called it. And what was particularly interesting about this tutorial, to be honest, I think my testimony was a complete waste of time, because it turned out that the judge, William also, everybody did warn me beforehand, he's a really nerdy judge. And sure enough, he was very, very into the science and was actually kind of all over it before I even started. But he wanted to hold this tutorial. And we had a very interesting morning with 2 hours of testimony from the plaintiffs. This was the case between the cities of Oakland and San Francisco, who were taking Chevron and various other co-defendants to court for selling the products that was causing the warming that would ultimately result in the cities having to relocate their airports. So it was a very sort of, it was a relatively simple case. You could sort of state the case in one sentence. And it was unsuccessful. The judge, despite, I'd like to say despite my testimony, and certainly despite a very clear understanding of the science, threw the case out. And I think it's an interesting point for us to reflect on what clearly worked for that judge and what didn't, and what caused him to throw the case out. Because I think the priorities of those of us concerned with climate science addressing the judiciary have been a little bit skewed up until now. So I went into this case thinking, as I think most scientists think, the main job of climate science with the judiciary is establishing causality, establishing that greenhouse gas emissions cause harm. And that's something that I've devoted a lot of my career to, actually quite a lot of it with generous support from Climate Central, who helped us set up the World Weather Attribution Project, which has really focused on this challenge of establishing the role of past emissions of greenhouse gases in specific harmful instances of extreme weather. And certainly when I wrote that article back in 2003, which you kindly mentioned, I thought that was the big problem. That was going to be the big challenge. Turned out Judge William also didn't need any convincing whatsoever of the science or the causal link between climate change and the harms that the cities were experiencing or likely to experience. And you could say, therefore, that while I firmly believe, I would hate to say, no academic would like to say, oh, my job's a waste of time, and move on. But I do think we need to, as a community, we do need to be careful not to obsess over the bit we know how to do and neglect the important bits that we don't. So to come on to the important bits we aren't getting right at the moment, was the moment in the case where I thought, sitting in the courtroom, we've lost it. And this was when, so I wasn't on the stand at this point, one of my colleagues was, and they were talking to the judge at the end of their testimony, and he asked, well, what else could we have done? I suppose we could have gone for nuclear. he used the word we, and he was asking the question, what was the alternate? And we the plaintiffs in that case didn't have an immediate answer for him. Ironically, the answer had been provided at some length by the defense, but nobody noticed. This was during the defense, which was provided by a lawyer, so that despite the fact that various rather eccentric scientists volunteered to testify for the defense, the oil companies quite sensibly just chose to present with use a lawyer to present. But he'd clearly been very carefully briefed about the kinds of mitigation options he should talk about. And so whenever he mentioned mitigation, he said, for example, carbon capture and sequestration, every time. And indeed, if you go back to the papers in the oil companies, which we were reading in preparation for this case, it's very clear that the industry's known very well that there are alternative things to do with carbon dioxide and dumping it into the atmosphere. But for various reasons, we didn't emphasize that to the court. And for the court, that was decisive. The companies didn't have any other option. And their only option was to sell their products, and then the CO2 would end up in the atmosphere. And because there was no other option, the court didn't see it as appropriate for the court to intervene and take the case forward. So I think that's just to wrap up. Good, I got the encouraging nod there. I do think
That wasn't the
No, it's
it's a
agreement.
good point, exactly. We're not just for time.
I'm trying to watch it. I think I'm about right. Just to wrap up, I think the direction we need to focus on this science law interface now has been to move on, slightly to my surprise, from the establishing causality question rather sooner than I'd have expected. I wouldn't have expected us to be in a position where so many judiciaries in the world just seem to say, yep, that's fine. We accept that greenhouse gases cause global warming and causes harm and all the rest of it. But we have to move on to the question of what is the alternate course of action that courts need to be considering for potential defendants in these cases. Because if there isn't one, then there's kind of no case. At least for many, it depends on exactly. I'm sure people in the room will be much better equipped than I am to comment on that. But certainly this issue of what's the ask needs to be much more to the front. And just really to wrap up, to quote, for example, the recent case in the Netherlands, which made a lot of headlines when a Dutch court, maybe there were people involved in that case in the room. Well done. So the court ordered Shell to reduce Shell's total Scope 1, Scope 3, Scope 2, and Scope 3 emissions, so including the emissions associated with products they sell, by 40% by 2030. If I have the numbers right, 45%. Sorry, which is but it's I gather under appeal, and I hope we'll come back. Maybe we'll come back to this in the Q&A. My concern about this is that the court wasn't very specific on what they wanted Shell to do, apart from potentially just get a bit smaller. And what I worry about is what one might call the Dong Gambit. Danish oil and natural gas company reduced its Scope 1, Scope 2, Scope 2, and Scope 3 emissions to essentially zero by selling them all off to INEOS, one of the sponsors of COP26. Which happens to be owned by a very loud climate denier, and became a wind energy company. Would this court ruling force Shell to do the same thing? And would that be a good outcome? I want to leave you with that question, perhaps specifically to those involved in the case, because courts have to, I think, have to start to engage with not just this is bad, fix it, but actually, what is the fix that they're actually asking for? Thank you.
Thank you. Very provocative. I do hope there'll be time to talk more in the question and answer at the end.
And now we'll hear from Judge Livio about the Climate Observatory or the Environmental Observatory.
Good afternoon, everyone. Thank you very much, Harrington, for inviting me to speak at this seminar. I'd like to thank you, the Alliance as well. It's a great pleasure to be here. So, in Brazil, the problem is the same. Judges are not educated for leading lawsuits regarding climate change and environmental law. So we don't have any kind of ability, technical ability to understand this case without being supported by lawyers, experts, technicians. So the task is really, really hard for us. And when we are talking about the forest, the Amazon forest, the hurdles is tremendous. The Amazon forest includes 9 states in Brazil and is bigger than Europe. We are talking about 107 ethnical tribes in isolation society that has never been in touch with the society. We're talking about 200 languages. We are talking about 24 million people living in that area. You can't cross Amazonia by roads. There isn't roads. The rivers are the roads. And sometimes you have to stay, the people that live over there have to stay 2 days, 3 days in the boats going from one city to another. And so we are talking about 2,000 kilometers of river between cities. Oh, this is not easy. The situation to be a judge in Amazon forest is really, really complicated. And sometimes there is just one judge to be in charge of an area equivalent to England's. And this is tremendous. This is really, really hard. So what the Brazilian judiciary has done in order to overcome these hurdles. First of all, the Chief Justice Fuchs created the Observatory of the Judiciary Power of Brazil, inviting the society, the civil society, experts, and people that are involved with the preservation of the forests, people that understand climate change, in order to deliver recommendations to judge, in order to organizing training, organizing research. Now, leading by Justice Herman, that is a member of the observatory invited by Justice Fuchs, we are able to organizing training, seminars, research, and understanding the problems that are being faced by judges in Amazon forest. So, what's the next step? We are talking about. We are not talking about digitalized lawsuits. In Brazil, 99% of the lawsuits are digital. We are not use paper anymore. The next step will be AI. We are aiming to use AI for understand the quality of the evidence. Can understand the problem to produce evidence in Amazon. Sometimes you can't see anything because satellites can see below the trees, and you have to use international satellites. Sometimes Brazil doesn't have this access, and there are many difficulties for understand the evidence and to use this in the lawsuits, in the trials. The next step, please. At the beginning of the history was the data jute. What is the data jute? Data jute is a national database of the judiciary. We are talking about currently 77 million lawsuits being tried in Brazil each year. It's something extraordinary. This was the first tool to understand where the lawsuits are being delivered, which kind of evidence are being used by judges, how many judges are in charge of environmental law. And for our surprise, last year, even being in a pandemic situation, the number of environmental lawsuits increased 17%. This is something really, really interesting because or the authorities didn't work, or people are using this situation to devastate the forest. The forest. The next one, please. We are talking in Brazil about night courts, night. And as we are a federation, we have the federal jurisdiction and the state jurisdiction. And each state has decided to use a kind of taxonomy to classificate environmental lawsuits. And then the work now was to create a uniform and harmonizing the way the lawsuits are filed in Brazil. If you are talking about Estonia, for instance, that is the most developed e-governance country of Europe. Estonia has 3 million people. Brazil has 200 million. And so the number of lawsuits is disproportional of the number of the population. Even considering that we are using intensive of technology, the hurdles are spread out for the states. The states in Brazil has a really autonomy in terms of organization of these courts. And this is a really hard, it's really hard for the National Council for Justice to harmonize everything. The next one, please. You can go to the next one. So this is the star of the Brazilian judiciary. This is the tool that is being built by the National Council for Justice, coordinated by Just Fuchs and by Just Herman Benjamin. Serene Junior is the most advanced tool, open source developed in the world about controlling lawsuits. We are talking about free and open source software. We can replicate this software to any country. We can share this initiative with any country, with any judiciary that would like to use that. We are able to use open data policy. And the most important, the next one, please. The Serene Jude will use geographic identification system. The main idea is to cross the data regarding lawsuits with the data that are being trial in the process, in the lawsuit, like evidence. The main idea is to construct evidence by satellite image in order to provide to the judge the polygon that can be used in that trial to prove that that area was being devastated by someone. Someone who, in fact, this is the worst problem. Sometimes when the problem came to the judiciary, there is no one over there, just the forest burned. And then locating people that are responsible for deforestation is a tremendous challenge for us Brazilian judges. This tool will be able, for instance, to locate the area, and then moving to the area, we are able to understand who was passing to that area in that time, to discover and blame someone about deforestation that was caused in some time. Can you go the next one, please? The next one. So this work began with European Union. We have currently partnership with European Union. We are developing projects to try to replicate the idea in Europe. Currently, we are aiming to choose 3 countries that could be partners in this project in order to try to use as a pilot, like replicating in countries that are using e-process, e-lawsuits as well. There is a really nice report in English that you can read, you can understand the problems and the origin of the initiative. And so the next step, or the most challenging step, will be the use of AI. Brazil is developing the Codex, that is an extracting tool in order to extract the pure test of the decisions, 7 million decisions, and then applying AI to understand how many decisions has been delivered, how many judges will be involved in environmental law. This number of judges is enough to deal with this problem. So thank you very much for your attention. It was a wonderful opportunity because since March of last year, I haven't seen any students. My students were at the clouds, or I don't know about you, but I couldn't order my students to open the camera. And then I was teaching to 100 students without know anyone. I have never been in touch with them, and I have never seen anyone. And then this is my first experience seeing students. You are the soul of the university. You are the soul of the teaching and the education process. You are wonderful. I was missing so much. Thank you very much.
I couldn't agree with you more about cameras in lectures. There should be a law. Switch the camera on.
Ariel.
Good afternoon, everyone. As the environmental justice lead at the Environmental Law Institute, I would be remiss not to speak briefly on the harmful impacts of a lack of ensuring compliance with climate regimes. The movement for climate justice stems from the movement for environmental justice. And the term environmental justice was coined in the United States and stems from the movement for civil rights in the 20th century, as low-income and people of color bore the negative impacts of unequal enforcement of environmental laws and regulations, unequal access to clean air and water, and received a higher amount of environmental burdens with fewer benefits than their more affluent counterparts. In both climate and environmental justice, we recognize that power, privilege, and income status have historically overlaid environmental governance and regulation globally. Climate change is fundamentally an issue of human rights and environmental justice that connects the local to the global, and studies have shown that climate change will cause human migration and displacement more severely than any war or crisis ever has. Climate justice is crucial because it is undeniable that those who have contributed least to the climate crisis are already and will continue to be impacted first and worst by the most harmful effects of climate change. Initial inequality makes disadvantaged groups suffer disproportionately from the adverse effects of climate change, resulting in greater subsequent inequality. Broken down, this creates a loop of inequality, increasing the exposure of disadvantaged groups to the adverse effects of climate change, like droughts, sea level rise, wildfires, severe storms, and the like, which increases the disadvantaged group's susceptibility to damages caused by climate hazards given their exposure level, which decreases these groups' ability to cope with and recover from the damage and harm that they suffer over and over again. So let's think about the climate-induced sea level rise, for example. Evidence shows that inequality often compels disadvantaged groups to live in areas that are more prone to flooding, which increases their exposure to flooding caused by climate change. And those living in these areas are more susceptible to the damages by flooding and are least able to recover. The only way that this closed loop system of inequality and harm for the most vulnerable can end is if we prioritize the needs and listen to those who are harmed by climate change most severely. Climate justice is a critical challenge across climate litigation, and many cases so far have been focused on the intergenerational limitation of livelihood that climate change creates. This intergenerational climate justice approach is a powerful way to attach legal responsibility to actors who fail to play their part in mitigating climate change. The Mary Johnson Foundation explains that climate justice links human rights and the development to achieve a human-centered approach, safeguarding the rights of the most vulnerable people and sharing the burdens of climate change and its impacts equitably and fairly. Climate justice is informed by science, responds to science, and acknowledges the needs of equitable stewardship of the world's resources. Scientific data provides a factual evidence to support arguments that sometimes are perceived as only political. However, validating and listening to the lived experiences of those most harmed by climate change is just as necessary. While many of the cases brought internationally relating to climate change so far have been focused on future generations, like the May 2021 Australian Federal Court decision that the Minister of the Environment owes a duty of care to Australian children who would suffer potential catastrophic harm from climate change implications, of approving an extension to a coal mine, and the Juliana case brought in 2015 that is still making its way through the court system on behalf of 21 youth, asserting that the United States government has violated the youngest generation's constitutional rights to life, liberty, and property. We cannot lose sight of the fact that the climate crisis is happening right now, and often those who are impacted do not have the resources to bring court cases against those who are contributing most of the harm. As such, the legal community has a responsibility to challenge specific resource extraction, resource-dependent projects, and environmental permitting and review processes that overlook the project's climate change implications, and to take more immediate steps and fulfill an obligation to all generations to preserve the planet. Thank you so much.
Thank you so much, everyone. What a fascinating presentation of so many important aspects of these issues. I want to first open up the floor. We have some official discussants, and I want to recognize them and ask for their comments. And then we'll open it up to a general discussion. We have Professor Tracy Hester from the University of Houston School of Law and co-director of their their environmental program there. And we have Corey Silverman-Roti from the Sabin Center at Columbia University. And Justice Benjamin, I'm going to just make you one of our discussants. Supreme Court Justice Antonio Benjamin from Brazil, and the founder of the Global Judicial Institute on the Environment. So
And a good friend of ours.
and a good friend. Professor Hester.
Well, actually, I'm glad to defer to Corey to start, since he's sitting at the front of the room.
Maybe a mistake. But no, sure, I'll start off with this with you. Just quickly, I'm Corey Silverman-Roti with the Sabin Center for Climate Change Law, as mentioned, and we've had a long-standing research interest in this connection between climate science and climate law. And as part of that work, my colleagues, Michael Berger, Michael Gerard, Jessica Wentz, and Radley Horton have been producing research papers, engaging with judges and scientists on this question of climate attribution, and specifically in the case, in the topic of climate litigation. As part of that, three of those that I mentioned published a paper on the law and science of climate change attribution, and this goes into depth into the key issues that go into these cases. We published a paper on climate attribution for takings cases, and we recently published a paper on climate attribution and Endangered Species Act cases. And I think an interesting aspect that comes out of those recent papers is that we should expand the scope of what we think about when we think about climate attribution beyond just these top line government responsibility and corporate accountability cases, and think about it also in terms of Endangered Species Act cases, environmental impact assessment cases, which tend to be a large number of cases, especially in the US, that come in climate litigation. And in these types of cases, attribution research can help persuade courts about the credibility of future predictions of climate change, which can help focus their attention on the impact that this will have in long-term threats to species, on the impact that this will have on climate impacts. And it's important for judges to understand in these cases that scientific uncertainty doesn't mean that the evidence that scientists might be presenting, as you did in your case, is not relevant. And there can be this confusion in litigation where, okay, there's some uncertainty about this science about climate attribution. Does that mean we should just reject this? Is this unknown? But that is incongruous with the legal rules on admissibility and relevance. Just to be brief here, I think on that uncertainty point, the most recent IPCC report also makes clear that each increment of pollution that goes into the atmosphere matters for each increment of increased temperature, and every increased temperature increment matters for the impacts for people on the ground. So this defense that, you know, I'm only partially responsible, all these other actors are much more responsible, falls apart in the face of this new science that tells us that every little bit that we add to the warming has an impact. And it's important for judges, I think, to look at that new science in assigning the obligations for the harms that climate change has caused. And that will only be asked of judges more as they go forward. Just to wrap up here, I think it's important to continue the work that the excellent work that ELI has been doing in bringing scientists and judges together. The Sabin Center is going to continue to do this work. We've built a climate attribution database with over 400 resources on climate attribution. That could be an excellent tool. Sabin Center also has a couple climate case charts, a US one and a non-US one, that can be a tool in seeing what other courts have done in analyzing these types of questions.
Thank you.
Thank you.
I'm not quite sure how to sit. So and just a little bit, I'll go ahead.
No,
that was
please.
to say, no, that's the last.
Yeah, please, no, please just
All right.
face the students.
Sure. So other way,
You can
Tracy,
move.
sorry.
You can come up here if you feel more comfortable.
Then I'm standing.
Yeah,
No
it's fine, it's fine.
Just, I'll be very brief. Tracy Heskey, University of Houston Law Center. I just have a few comments. One, I strongly recommend the paper from the Sabin Center. It is a 184-page magnum opus on all the aspects of climate attribution. Professor Berger and Jessica Wentz and is it
Bradley
Gordon? Yeah, did a superb job. I highly recommend it. Number two, I will also offer a provocative comment. So rather than heckling others, I might be having instead. Namely, there are in the United States close to 30 state law cases percolating through the system. The fight has all been over which courts they'll be in. That is a prelude. At some point, one of those cases, and probably several of those cases, will proceed to an actual trial. And we'll get to this attribution causation proof issue. What I'll suggest is it's going to depend which courts and which context, and we're going to get multiple different answers. So the area I see after this one, and yes, we've got a lot of work before we get there, so I'm probably getting way ahead here, is how to figure out the way to harmonize and enforce and pick between potentially inconsistent verdicts. So it's going to matter if you have a state court or a federal court judgment that's being enforced in a different state. It's going to matter if we have a foreign judgment in another nation being enforced in the United States. That entire body of law has not been thought through from a climate perspective, a climate liability perspective in particular. And we've had some very convoluted law in the United States on how to enforce those kinds of judgments between different systems. A lot of it's rooted in common law that goes back over 150 years. So I would point out that a couple of things that are likely to happen. If we get judgments that are sought to be enforced in the United States, that people in power object to, we're going to probably see attempts to change the standard as to how tort liability can be imposed to those kinds of judgments. That could be either done by statute. For example, we already have a federal law in the United States that bars enforcement of defamation lawsuits brought in nations that don't meet First Amendment standards in the United States. It's very easy to just carve out that sort of enforcement of other kinds of judgments. That is going to be rooted in causation. If there's a belief that another court system has not properly attributed causation and fault, there are going to be strong resistance to enforcing that judgment. The other is, at some point, I think you're going to see more interest by states setting up barriers. For example, in Texas, where I teach, there's already a statute that essentially prohibits climate tort lawsuits. If you have a permit for air emissions, that's enough. It gives you a presumptive defense that it cannot be you cannot bring a climate tort lawsuit based on CO2 emissions. So look for that sort of attribution issue to purple up as a conflicts issue. And with that, I'll stop so we can actually, if there are any other comments or anything else anyone would like to ask about.
Thank you, Professor Esper. Justice Benjamin, do you want to make some remarks and then hopefully we'll
Well,
open
first
it up?
of all, to say that I will reciprocate, asking you the next time we are I am in the podium, when you are in the audience, without no notes, and then say, you know, we are discussing.
Is that reciprocity or retribution?
Oh, it's retribution. I wanted to be kind and not really scare my dear friend. Well, this is a fascinating panel, but it's a fascinating panel because one, the theme is relevant, and second, because we have fantastic people that are knowledgeable about it. So I'll make 3 comments, and all 3 comments have the intention to show that we need to have a one-day event just about that. First, about the relationship between science and law. We tend to think this is something recent. But just remember that in criminal law, it was science that came with fingerprinting. It was science that came with the blood tests, not DNA. This is much more recent, like family law and blood tests were really important in criminal law and so on. So this is something that is not very recent, and it doesn't come up with climate law. The question for our next event is what makes it different in climate. And that's what the scientists have to begin the conversation with the judges. You have been dealing with this for many decades, and I'm not even mentioning intellectual property, technology, patents, and so on. Science has always been in the courtroom, like what makes climate law so different? That the importance of science is beyond the imagination of an ordinary judge. So this is the first point. The second point, and perhaps it's another seminar separated, so we have perhaps 3 days in a beautiful place with good weather and time to enjoy the place, which is not here. We are just locked in different rooms. The second is about causation, which was discussed by at least 3 of you. There are 2 types of questions here for judges that interest us. And when we say that it's settled, one is settled, but the other is not. The one that is settled is whether those things that we don't see, that we call gases, are causing climate change. Because if we call them greenhouse gases, we are already attributing some responsibility to those gases, right? That's why I'm calling them those things that are invisible. Well, this is happening. I don't know any judge, perhaps in the United States, because you have a different type of judiciary. The way you become a judge in the United States is quite different from the rest of the world, but nowhere in civil law, I mean, among us, we have any doubt. And it's not just the choir, we're talking about every single judge, that climate change is being caused by those things that we humans, not nature, not the sun, not the way the planet is moving in space, our actions are causing. So this is settled. What is not settled is whether climate change is causing the type of damage, concrete damage, that we are suffering. Your communities that you mentioned, the flooding, sea rise, and everything. So that's where science is more important. Don't waste your time trying to convince judges that the first issue, causation issue, that's not an issue. It's the second one, and then we can have a full day of discussion. And as you mentioned, it's your paper. I'm now curious to see the paper. You have a very good PR here. And I'm the third, and I stop here, is about what Judge Marcus Livio presented. Because this is really revolution, what's happening in this National Judicial Environmental Observatory. Because Brazil is a federation, as the United States, with state Supreme Courts, Federal Court of Appeals, and 2 national courts. Really to have a powerful system to bring all those pieces together. Then the issue of combining and using artificial intelligence to combine the lawsuits that have been filed with the geodata that shows where the deforestation is happening. Does this correlate? Do we have more lawsuits where the deforestation in the Amazon? And the answer, the preliminary, didn't mention this, the preliminary answer is no. The great majority of lawsuits are happening in our part of the country, not in the Amazon. Why? Because we are not there. And then we get the answers to how we are going to redesign the Brazilian judiciary. And then finally, this is important to translate in almost in an automatic manner, in which judges are very automatic. No, justice has to be individual. But the translation of the data and the transport of the data can be automatic, not the decision. So why for every suit, the Federal Office of the Attorney General, the State Office of the Attorney General has to do everything and not just have a communication system between the satellite agency, the Environment Protection Agency, that is sent there, and then the lawsuit is, or the text is already there, and then there is just a final review and it's filed. So almost 3,000 major lawsuits have already been filed in such a manner, and they were challenged in the federal system, and the appeals came to us that this was illegal and unconstitutional. Doing this type of thing. So you use GPS for in war and in war zone to attack one tank, but you cannot use it in the judiciary. Does it make sense? Planes fly, drones fly around the world using GPS, but cannot be used under Brazilian procedural law or any type of procedural law. I mean, procedural from any type of thing. But this is for another event. So we have 3 events here.
Thank you very much, Justice Benjamin.
May I respond to some of these?
Yeah, quickly,
Please.
although I do want to
Get
hear
some
some from the audience.
Well, Tracy brought up an interesting point of there are particular rules in the US about federal courts deferring to state courts, states deferring to federal courts. I'm not sure that they're ever going to get there. At least some of them are going to pass the buck back and forth, and it's going to be continuous going around. And no, there are certainly some states where you may have significant difficulty in getting your case heard at all. But it also raises a point that I think has been, ELI has seen in our work with judges around the globe, and that is that the lack of knowledge about environment, environmental law, climate change, has led to many judges taking those papers to case. And so put it under my desk because I'm afraid of this, or I don't know how to handle this. This comes back to the importance of raising the awareness of the judiciary about the issues, the knowledge that's available to bring to them by the litigants to help them decide these cases. That by doing that, you just increase the ability to resolve these kinds of disputes.
After me jealously guarding time for questions from the audience or reaction from the audience, I hope there are some questions or reaction. Yeah, please go ahead.
Yeah, so I'd love to comment through it, Dr. Allen. I am the lead researcher in the climate case against Shell for Friends of the Netherlands. And you mentioned that maybe that the verdict would have no effect because potentially everything that Shell sells off would be taken over by other companies. In the verdict, the judge actually takes the stance that even if that were to be the case, that doesn't matter because the issue is so important and so urgent that every emission reduction counts, which I think is quite revolutionary in that sense. And then second of all, she also disputes the fact that that would be the case. So she says there is actually no such thing as perfect substitution, as is also supported by the evidence that we gave from the production gap report and the evidence provided by Ericsson. Yeah, I think we can discuss this for an entire day. But I just wanted to get a bit of a sense of what we as plaintiffs can also do to help judges understand these cases, because when looking at our case, I think we've handed over thousands and thousands of pages of reports, and what we've tried to do is make the sources as reputable as possible, so including as the least NGO type of reports as possible. But I was just wondering in this expert panel if you have any tips for plaintiffs that want to sue corporations, governments, what we can do to make our cases heard and make sure judges understand. Because I really empathize with them having to go through all of these things that are needed to judge a case like this.
So what we found also, so I should emphasize that our project does not attempt to support the plaintiff side only or the defense. On the contrary, that what we're trying to do is present the objective, neutral facts that are about climate science. And what we have found is that in doing that, many of the judges are very thankful in being able to assess how they can use the scientific information and data to make judgments. So I guess that the point is, and it's a very interesting point that you make, the judge is speaking to the value of the remedy that is being brought forth. And I think I heard Miles also speaking about the importance of developing a better understanding of what remedies can be. And this is perhaps an area where science can also make a contribution. What can we do alternatively to help solve the problem?
Yeah, I was going to say, I think the answer is not about what plaintiffs can do, but just what people who understand can do to put out clear information about science or about what could have been done alternatively so judges can understand. I mean, and like Paul said, we can't, you wouldn't be able to do it, the work we do with the judges if it was on one side or the other, but if it's just facts and just basic information, then that's
very powerful.
That's exactly right. So
Sorry, just a very quick sort of response to that. Yes, obviously I'm not familiar, obviously not as familiar as you are with that case. So it's a landmark case, and I feel because it's a landmark case, there's a lot to talk about, and that's why. But what I am aware of is there is globally a trend towards fossil fuel extraction moving to less accountable bodies. So we see a coagulation of fossil fuel extraction into national state-owned companies in jurisdictions that are probably not so accessible to the kind of courts that we're going to be talking to. And so if the net effect of these cases is to accelerate that trend, then in the very big picture, I'm concerned that that would be a, you know, that is going to be a long-term problem. And so that's why I think, you know, for all of us to think about what the ask is of these companies and how they can, you know, going back to the previous panel on climate repair, you know, should we be asking companies to fix what they're doing rather than just stopping doing it? It's, you know, it's a different kind of ask. It's whether we're asking companies to do something positively rather than just stopping doing something that's causing harm. It's a long conversation, but that was kind of what I was alluding to.
You, then you, and then you.
Thanks for the very interesting panel discussion. I'm a lawyer at the Agenda Foundation and the Climate Litigation Network, and we support litigation against states in relation to their overall mitigation ambition. And I wanted to join the discussion about the role of science in informing that litigation, and particularly on the question of remedies. And in response to Dr. Allen, your suggestion about more specificity about what could be done at the remedy stage, we found that that's actually quite problematic. That specificity is needed at the breach stage to show indicative standards of what you should be doing. So in terms of emissions reduction, what your fair share is, but it would be quite detrimental for a plaintiff to prescribe where the emissions should be reduced or what measures should be adopted by, for example, in our case, the state in question, because that would be seen to be stepping into the executive's area of discretion. So it's quite we found it's quite a subtle and important boundary where the scientific evidence is really needed on standards of reasonable conduct, but not to be too prescriptive. And very much the Dutch court says we are not telling you, the Dutch government, how to reduce emissions, but we are setting a line about the minimum level of emissions reduction. And I think that if you start to prescribe, be more specific, you could end up having cases more readily rejected on grounds that it's not justiciable or you're interfering with policy discretion, which I think is an interesting dynamic that we have to be aware of when we're litigating these cases.
Thank you.
That's very interesting. I wonder though how much that is different in different country systems, because
Sure.
in the US it's often they throw you out because they say, well, there's nothing we can do.
Yeah.
So interesting.
Yes.
Yes, Justin.
Can I just say something? I don't comment on litigation and, from a comparative law perspective. And what I'm going to say, it's neutral. Or at least I think it's neutral. We more and more have those events on climate litigation, but we tend to forget that adaptation is part of climate change, and we only focus on mitigation. So most of the discussion here today, if not everything, is about mitigation. But we cannot forget that, you know, because the scientific knowledge will be necessary there too, even more in terms of adaptation. Then we need to think about adaptation as well. Otherwise, we will be handicapped. On the specific question that I'm not going to answer, it has to do with remedies, but it is relevant to understand that some countries have a closed list of remedies. Other countries have moved into a paradigm that is very friendly to climate change, although it was not done for that purpose, in which the judge has not the power but the duty to come up with a remedy that is appropriate for the type of damage or complaint. So that's the case of Brazil at the moment. And then things change entirely because you also need to educate the judges or inform the judges about the scientific possibilities that are there for remedies. So it's perhaps the fourth event.
Thank you. Yeah, I have to say, I guess if you wanted to go to the plenary, it's about to start, but we're allowed to stay and keep talking here, so I hope many of you will be able to stay for a little while longer. Let me call on him and then you.
So this is a question more for the scientists in terms of, we accept that humans have rights, and do scientists accept that nature has rights, and that could be a sort of preliminary injunction in certain cases, and then what I think about, because I think in terms of biodiversity loss and giving nature rights could be one of the key concepts to develop, but it makes sense about
One thing I'm very sure is about the question of whether nature has rights is not a question for a scientist. I'm sorry.
in a sense, you would accept that humans are part of nature. Yeah,
Of course. Yeah, no, I mean, but I just think there's other people in the room that are qualified to answer that question.
agreed.
Anyone want to react about rights of Jay?
This is clearly a developing area of the law, developing a lot faster in, say, Justice Benjamin's court and others in the Americas outside of the United States. But I think it is one that there's a lot of thought going into it, and there's certainly a number of groups that are advocating for that. And I think it's I won't look for it to be developed in the US very soon. A lot of other places, yes.
So I just want to preface this by saying I have a near complete ignorance of the law, so this might not be a legitimate comment, but it occurs to me, just to build on Miles's point, it occurs to me that some remedies could actually work counter to the purpose of the case itself. So there's these well-documented instances in which assets have been sold off to a Czech private equity firm, and then the average emissions actually rose afterwards. So if that's the inevitable result of certain types of remedies, surely that could come into the case somehow, such that there's going to be close not sell policy or something like that, because it's not just national oil and gas companies or whatever, it's also other entities within the financial system. And surely there must be a legal way of preventing that from happening. It runs counter to the whole point.
Yeah, I think that's a really interesting and very valid, legitimate point. And I think it's definitely a risk. I think a couple of things come to mind for me, but I'm sure others have reactions too. One of which is sometimes we talk about the roles of judges in ensuring that their decisions are carried out properly. So that's a kind of evolving, innovative, not very standard area that happens more in other parts of the world than in the US. So there could be a role of the judge saying like, no, that's not what I ordered. It's, that's not the intent of what I ordered. But then otherwise, I think it has to be thought through before the case ends. So it's a fact issue, but yeah, I would see it as part of the case. Justice Benjamin.
Now we are moving into remedy again.
Yes. That's where it is, though. I mean, that's why I loved Miles'
No, but we
presentation.
begin with causation.
Yeah.
So,
Well,
and now with
we haven't tried
remedy.
that.
You see, when we read a book about remedies, it's usually written about the immediate impacts of those remedies.
Right, the short term.
The short term.
Exactly.
So you prohibit this company from doing this type of behavior. And then you say, well, this company, and I'm not talking about climate change, this company is not going to be doing this anymore, but the bad guys will take that space. It's the drug cartel issue. You eliminate one, and then there are 3 or 4 waiting to take their place. Now, look a little bit longer in the case of corporations. If this is happening with the big ones, you are breaking the coalition. no common interest anymore. And those that are submitted to those remedies will become an ally against the competitors that are replacing and benefiting from that prohibition. So it is important that we look at remedies not just from a short-term perspective, but from a long-term perspective. And then, and of course, this is beyond law. It's not in the statutes, but it's in line.
All right, I think we've used up our time. I want to thank you all very much for being here. As Justice Benjamin said, there's at least 4 more days of discussion to be had from the topics raised here. So let's continue the discussion as we go forth in our work. Thank you.